Thanks for joining me. Thomas Paine said back in 1792 that liberty is the power to do everything that does not interfere with the rights of others. Thus, the exercise of the natural rights of every individual has no limits save those that assure to other members of society the enjoyment of the same rights. Thomas Paine in 1792. Thanks for joining me for the lunchtime version of Freedom is Scary. This is episode 19, a live video on the topic of the most misunderstood political law that there is out there, and that's qualified immunity. So the answer to all of the issues really that we face today is more freedom, not less. Not more police, not more jails, not more laws, but more freedom. And it was supposed to be that way from day one. Looking back at some of the founding fathers and their inspirations, Thomas Paine said in 1795 that he that would make his own liberty secure must guard even his enemy from oppression, for if he violates this duty, he establishes a precedent that will reach to himself. And that was an early answer to the question of, well, why should I care about the rights of somebody I don't like? Or why should I care that the guy is a registered sex offender or that guy did X, Y, and Z? Well, Thomas Paine answered that question back in 1795 because there's a very selfish explanation, a very rational explanation for why you should care. Because if you want to make your own liberty secure, you have to guard even your enemies from oppression. Because if you violate that duty, and that is your duty, you establish a precedent that will later affect you, or maybe your kids, maybe your grandkids. Can everybody hear me all right? Yes. All right. Another one of my favorite quotes from one of the early Americans, Thomas Jefferson. Timid men prefer the calm of despotism to the boisterous sea of liberty. I can think of a few people in this year, 2020, that Thomas Jefferson had anticipated back in 1796 when he said that, or when he wrote that, rather. Our governor here in West Virginia. Do you think that he prefers the calm of despotism to the boisterous sea of liberty? Thomas Jefferson was basically describing what we now call a Karen, but back in 1796, we just called them timid men. Our governors, many of them, especially our governor here in West Virginia, that's a timid man. He prefers the calm of despotism to the boisterous sea of liberty. So this video, getting back on topic, is about qualified immunity. On any video I post or any social media post that I share having to do with some sort of police misconduct, you hear people talking about qualified immunity. We need to get rid of qualified immunity. We need to adjust qualified immunity in response to a lot of what happened with George Floyd. How much talk did you hear even from Congress about qualified immunity? So I deal with qualified immunity. Excuse me. Let me take a client of mine gave me some Death Wish coffee, so this might help. I deal with qualified immunity for a living, so I know what it means. I'm not saying I like it, but I don't believe 90, 95%, maybe 98% of the people who are out there talking about qualified immunity have any idea what it is. So qualified immunity applies only to civil lawsuits for damages, not criminal cases. So a police officer who engages in misconduct, or really any government employee who engages in misconduct while on the job under color of law, they cannot assert qualified immunity as a defense to criminal charges. It's not a criminal defense at all. It's absolutely irrelevant. Jeff, I think I already feel my hair growing right now, and that's not even a problem that I have since I just turned 40 a couple days ago. I've got plenty of hair growing where I don't want it to grow. Back to the issue. A police officer cannot assert qualified immunity. If a prosecutor is going to prosecute a police officer for a shooting, for a use of force, whatever the case may be, qualified immunity is absolutely irrelevant, has nothing to do with it. It only applies as a defense to a civil lawsuit for damages. So Section 1983 lawsuits is basically the area that I practice in, and that allows private citizens, Americans, to sue their government officials, including police officers, and mostly police officers that this applies to, for violations of federal rights that were performed under color of law. So you may have heard the term Section 1983 lawsuit. That is a federal civil rights lawsuit, and you can only sue based on violations of federal law. So federal constitutional law, federal statutory law, something like that. You can't file a Section 1983 lawsuit for violation of merely a state right. Qualified immunity is only a defense to these civil lawsuits, and primarily these Section 1983 lawsuits. While acting under color of law, they cannot apply to a defense for a criminal prosecution. They first came, this was a creature, you talk about legislating from the bench. Right now, they are discussing constitutional theory. Well, they're supposed to be discussing constitutional theory with Judge Amy Coney Barrett. Now, talk about legislating from the bench. That's where qualified immunity came from. It came from the United States Supreme Court in 1967, originally with the case of Pearson v. Ray in 1967. In its current form, it was adjusted in 1982 with the case Harlow v. Fitzgerald, and that's basically what we still have today. It was adjusted somewhat in the 2009 case of Pearson versus Callahan. But here's the three basic steps to stripping a police officer or any government officer of qualified immunity. And again, this doesn't apply to only police officers. Any government actor, any government employee, so long as they're acting under color of law, is liable to be sued under Section 1983 if they violate some federal right that you have. So you're usually dealing with police officers because they're the ones out there arresting people, enforcing the law, putting people in handcuffs. But it also could be applied to other individuals. I had a case, for instance, once where my client had a seizure, and there was this altercation between the EMS personnel and my client. And there were allegations that there was basically excessive force when the EMTs grabbed onto him. And so we sued them under Section 1983, and they weren't even actual government employees. And so you can get into some legal gymnastics if there's enough of a connection there between the government and the person that you're suing. But primarily you're talking about suing police officers. So to strip a police officer of their civil immunity from damages under qualified immunity, there are three steps to it. One, you have to show that the police officer's conduct violated some federal statute or constitutional right. Secondly, you have to prove that that right was clearly established at the time the conduct took place. Third, an objectively reasonable officer would have understood that that conduct violated that constitutional right. Now, I said that those were three easy steps, but that's somewhat of a lie, because those steps really are not easy. And here's sort of the unjust part of the whole qualified immunity thing, is that you can't just prove that there was a civil rights violation. you have to prove the 3 steps, that there was a civil rights violation, which isn't easy to prove. A lot of people think that's all you have to prove. No, you have to prove the civil rights violation and that it was clearly established at the time of the conduct, and that any objectively reasonable officer would have known that. And so what that means is that you have to point, so you show a civil rights violation, and then you have to look back at the case law, usually federal case law, and point to similar cases that would have put anybody that pays attention to federal case law that what the conduct was has already been declared by a federal court to be unconstitutional. And third, the last part of that is another difficulty that comes because it says an objectively reasonable officer would have understood that this was a violation. And that the key word is objective. So it's not a subjective standard, it's an objective standard. It originally was a subjective standard back in 1967. They originally did have a subjective standard. That is one of the changes that took place, and that was in 1982 with Harlow versus Fitzgerald. They changed it to an objective standard, and that becomes very important in litigation over qualified immunity. For instance, a state trooper could go track down the guy who's having an affair with his wife, and he maliciously pulls him over, but he failed to use his blinker when he turned. So he did commit some traffic infraction, but that's not really why the trooper's pulling him over. The real reason why he's pulling him over is because the guy's having an affair with his wife and he wants to rough him up. But he did observe the guy make a simple traffic infraction. So he does rough him up. The victim sues, and he alleges that it was an illegal stop, that it was unlawful to stop him just because he's having an affair with the guy's wife. And the police officer's lawyer says, well, wait a minute. It's undisputed that he didn't use his blinker when he turned. Therefore, there already was a legal basis to make the stop. There already was reasonable suspicion that a traffic infraction occurred. So if we're using the objective officer standard, an objective theoretical good cop who's sitting there would know that he could pull this guy over and it would be completely legal. It doesn't matter because it doesn't matter that wasn't the real reason, the subjective reason, because the courts aren't going to look at the real motivation of the officer. They're not going to look at the real motivation was that he was going to engage in this unlawful retaliation against a citizen and abuse his authority, abuse his badge for his own personal reasons. An officer can get away with that under qualified immunity because of the objectiveness of the standard. And a lot of people don't understand that. And a lot of lawyers don't understand that. And so that is one of the worst parts of qualified immunity. The coffee it's not bad. So what does this all mean? I understand that people don't watch long videos about qualified immunity because I've tried it before. Let's get down to the basic bolts of qualified immunity. How does it work in practice? Well, here's how this all pans out. Most importantly, there tends to be a grace period in between courts declaring some sort of conduct unconstitutional and officers being held liable for it for qualified immunity purposes. So if a court says that certain conduct is illegal in 2019 and this officer does it in 2021, is the court going to find that it was clearly established enough for an objectively reasonable officer to have known that they shouldn't have done that in 2021? I don't know. That's a gray area. That's where the discretion of the judges come in. But there does tend to be a grace period. So The similar case declaring that conduct to be unlawful needs to be as early as you can find it in the case law. For instance, you may have seen the recent video I posted of discussing the police arresting somebody they had an arrest warrant for, who was a third party who was visiting my client's house. Back in 1981, the Supreme Court in the Stiegel case said that you have to have a search warrant for that structure if you're going to go arrest a third party in a house. Just because you have an arrest warrant for a third party does not mean that you can go inside that house without a search warrant or consent of the homeowner or resident or exigent circumstances. That's been the law since 1981. So that's a very, very good case of being clearly established, well established. It would be very difficult to argue that a 1981 Supreme Court precedent was not clearly established. Now, if it was a 2020 Supreme Court case and the conduct happened in 2019, then yeah, there might be a problem because it hadn't occurred yet when the officer committed that conduct. And therefore, he very well might get qualified immunity for it because it wasn't clearly established at the time the conduct took place. So there tends to be a grace period. Secondly, qualified immunity is generally a poor defense, even for police officers with excessive force cases. This is what frustrated me so much about the George Floyd situation, is that even Congress, they were talking about qualified immunity. It's just this outrage that we need to fix. I agree. I would love to get rid of qualified immunity. I would do very well if we could get rid of qualified immunity, but it's just disingenuous to attach it to the George Floyd situation at all, which had nothing to do with qualified immunity. First of all, like I said, qualified immunity is not a defense to criminal charges. That guy was charged criminally. His lawyers cannot assert qualified immunity. Now, no doubt there either is or will be a civil lawsuit. Maybe it's already settled. I don't know. Qualified immunity could be asserted by his lawyers or by the lawyers for the other officers who might get sued. But it's a really poor defense to excessive force claims. This is because excessive force claims, usually there's no big dispute that you're not supposed to choke people to death or shoot them to death or kill them to death where it's unnecessary. There's zillions of cases standing for that going way back. That's very understood. There might be some excessive force cases that could be sort of a gray area, like the last qualified immunity case that went to the Supreme Court, where the police were called and then there was the woman standing with a knife, and she wasn't really a threat to the lady they thought she was a threat to, but they had just gotten there and they told her to drop the knife. She didn't drop the knife. There could be a gray area like that, and that's sort of what happened. That came out of the Ninth Circuit. But just with a straight up intentional use of force case, police shooting case, a beating case, you're almost never going to have to deal with qualified immunity. And that's part of the reason why I like to litigate excessive force cases, because qualified immunity probably isn't even going to be raised. It's not even going to come up, because the issue is not going to be a legal one. It's going to be a factual one. For instance, the plaintiff alleges that a police officer punches him in the face, or let's say he punches him in the groin while he's handcuffed behind his back in response to the arrestee insulting his mother. If that's true, that's going to be excessive force. The judge will agree to that. The defense lawyers will agree to that. And certainly the plaintiff's lawyer will agree to that. Probably the police officer is not going to admit that, or maybe it didn't happen. Who knows? what's going to happen is the plaintiff will allege it happened that way. The defendant will deny it. He'll say, no, I didn't hit him in the groin, or he was out of control and trying to kick me, and he may have gotten hit in the groin, but he was resisting arrest and he was assaulting me. And then the plaintiff, his story was that he was just standing there insulting his mother. So those are factual disputes. That's why we build courthouses. That's why we have jury trials. So that whole case is going to be about determining the factual dispute there. Was he kicked or punched in the groin? And when was it necessary when he did it? I mean, was there some excuse for it, or was it just completely malicious and unnecessary and in violation of the law? Because you're not, if an arrestee or a pretrial detainee, they can insult you in any way they want. If you're a police officer, they could come up with the worst and most offensive thing to say to you, and it's very clearly established law that you can't kick them in the nuts. You can't punch them in the face. You probably would want to, and as a private citizen, you probably would. But when you have the badge on, if you do that, you can get in big trouble. That's very clearly established law. So that's why I'm using that example. So that's excessive force cases. If they're good cases, they're going to be factual disputes that will make it to trial. They'll make it to trial almost every time. Qualified immunity generally will not come up at all. The big exception to that is shooting cases where the subject dies, where he's killed, and there are no other witnesses. Because what do you have there? Every police officer who was involved can give an affidavit or a deposition about their side of the story, what they saw, that the person was trying to run them over, or pulled out a gun, refused to drop the knife, whatever the case may be. And the other guy's dead, he can't testify. So where you only have one side of the story, a lot of times you won't make it to trial in those cases, or there'll be qualified immunity in those cases because the judge only has the officer's side of the story. So generally, it's a poor defense to excessive force, but it's a very good defense with search and seizure issues. And this is why I generally don't like to take search and seizure cases unless I'm just really interested in the case, because they're a very, 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 there's a very good likelihood of qualified immunity being granted. Now, search and seizure cases, they come mostly out of criminal litigation. So every guy that gets arrested, just about, or at least every guy that makes his way to prison, has raised some issue of search and seizure. So whether there was a problem with the warrant, or whether there was a lack of probable cause or a lack of reasonable suspicion. And these issues get litigated all the time. There's a lot of case law coming out every year with search and seizure type issues. In every federal circuit and state courts, it's always changing. Therefore, like I said, the courts will give this grace period, and they'll give they have this sentence that courts will put in these qualified immunity cases that hindsight, we don't judge police officers by 2020 hindsight, that events are happening quickly, and we don't judge them by a standard of perfection. We give them the benefit of the doubt. So search and seizure cases, a judge is going to be very likely to grant them qualified immunity if they make some technical violation of the law. So even if you can make a very clear case that some technicality was violated, now that's going to help you in the criminal case. That can definitely win the criminal case. But again, qualified immunity doesn't apply in criminal cases. So if you want to get civil lawsuit damages for that technical violation, you're probably going to have a problem with qualified immunity. So it's very effective in search and seizure cases. And it's going to be more effective where it's not as clearly established. So the 1981 Supreme Court case, it's going to be hard to get qualified immunity if you engage in a clear violation of that, because hell, that's been around since you were maybe before you were born, if you're the police officer. Or we could look at if you've seen my YouTube video about the officers sneaking in the window and searching this guy's house with no warrant. If you look at the issue of whether the landlord could have authorized them to do that, hell, you can go back to I think it was 58 or 1960, somewhere around there, Supreme Court case from the Prohibition era that said even if the landlord smells and hears an illegal alcohol still operating inside the structure, he cannot give you authorization to go search that house and seize that still without a warrant. You still have to get a warrant. So where you have established Supreme Court precedent for 60 years or 40 years, that's always going to be hard to get qualified immunity for a police officer. But where you violate something that is has just came down, and for instance, if the Supreme Court said in 2019 that, well, if you keep the occupant of a home handcuffed during a search of their structure pursuant to a search warrant, if you keep them handcuffed for 3 hours, that's legal. Any minute beyond 3 hours, that is illegal. That is unreasonable under the Fourth Amendment. So the next year, 2020, they search your house, they have a warrant, they handcuff you, and they keep you handcuffed for 3 hours and 4 minutes. That's going to be a great case for qualified immunity because it's pretty much in line with what the law was not too long ago. And I'm just making that up. That's not what the law is. They can handcuff you, but there's no exact time period. It's going to be a good case for qualified immunity because it's very, very close. Yes, it is a technical violation. It is a technical violation, but it really wasn't clearly established for the theoretical, objective, good police officer who doesn't know everything and doesn't have 20/20 hindsight, but he's a pretty good guy. And that's how the courts judge the officer. They don't judge the act. Remember, it's an objective standard. They don't judge the specific officer. Remember my case with the YouTube video about Michael Walker, my client, who was walking down the side of the road with an AR-15, and the officer friendly comes up to him and says, "You little cocksucker. I can get your ID anytime I want to get your ID." Even though that guy was completely wrong on the law, his lawyers can still say, yeah, but even though that guy didn't know what the hell he was talking about, the theoretical objective officer, hell, he could have seen that AR-15 and thought, this might be a school shooter. And therefore he had reasonable suspicion to stop him. And that was their argument. And the court went essentially with that argument, which we're appealing right now. So that is the point about qualified immunity that people don't understand. It's not about George Floyd. It has nothing to do with police beatings or police shootings, really. It's about those types of cases. It's about search and seizure. It's about technical violations, about areas of the law that are changing, so-called gray areas. So what that means is that, yeah, an officer can make a mistake of either the law or a mistake of the facts. For instance, the case in California where they shot the woman with the knife, where she wasn't really a threat, according to the woman standing next to her. But that's what they thought when they got there, because that's what they saw. So there was a mistake of fact, but they got qualified immunity in the end. Or it could be a mistake of law where, he thought it was the officer that handcuffed the guy in the house. He thought it was 3.5 hours he could keep him handcuffed for, not just 3 hours. So a court could find that was a reasonable misunderstanding of the law. Again, we don't hold them to 20/20 hindsight. So that is where qualified immunity is going to apply, some sort of reasonable mistake of law or fact, usually in a search and seizure scenario, but sometimes, rarely, in an excessive force scenario, but usually search and seizure. The other place that qualified immunity is a really effective defense. Not that I want to educate the lawyers that I'm fighting against, but they know this anyways, generally, because this is a very specialized area, and a lot of the defense lawyers that I fight against, they're in practically every case. So, they know this stuff, backwards and forwards. But qualified immunity applies as a very effective defense in wrongful arrest cases. So where the court looks at the facts and the record and says, and I just had this happen to me at the Fourth Circuit out of the Eastern Panhandle. It was a clear wrongful arrest and unlawful search case of a high profile person. And that's why it was done, because this is a candidate running for office and they see blood in the water. They go in without a warrant. They make an arrest where they would never make an arrest of the average citizen, just to, as we would argue, affect the political campaign, the political outcome. And even though it was very clear in this one case, the trial judge, the federal judge, said, yeah, even if it's a civil rights violation, I'll give them qualified immunity, because there's probably enough there that the officer could make a reasonable mistake at probable cause. And then the Fourth Circuit ends up saying the same thing. And it's very frustrating. So wrongful arrest cases, if you have trouble finding a lawyer for a wrongful arrest case, understand that hell, you can go through all the steps, gather the evidence, take the depositions, prove that this was a wrongful arrest, and they can still just grant him qualified immunity, or her, because we're allowed to look at all the available evidence, and we think there's probably enough there for that theoretical, objective, perfect, well, not perfect, but good cop, that good guy. Now, even, we're not going to look at this specific guy because it's not a subjective standard, but the objective good guy cop, there's probably enough there. We're going to give him qualified immunity. So those are difficult to win. The search and seizure cases are difficult to win unless you just have very clear violations of very long-standing case law, like some of the examples that I gave you. So that's why wrongful arrest cases can be pretty difficult. And a lot of these issues are difficult for the judges as well. In that case I just told you about out of the Eastern Panhandle, heck, the federal judge, the defense attorney in that case tried to claim that wrongful arrest claims under Section 1983 federal law had only a 1-year statute of limitations, as opposed to a 2-year statute of limitations, which we usually have in West Virginia for Section 1983 cases for civil rights violations. So even the defense lawyer believed it to be 1 year and convinced the federal judge that, it's 1 year. And it is confusing because under West Virginia state law, the state tort claim of wrongful arrest or malicious, or they have a few different names, false imprisonment, etc., has a 1-year statute of limitations. So they tried to apply that to the federal claim because generally federal law will borrow the state statute of limitations. But there's a U.S. Supreme Court case saying that, but not for every little claim. They take the general tort statute of limitations, which is 2 years in West Virginia. So I had to appeal that issue to the Fourth Circuit and won on that issue. And the Fourth Circuit said, no. Under federal law, federal claim of wrongful arrest is still a 2-year statute of limitations. So these issues can get really, really, really deep in the weeds. And another thing is qualified immunity can also be put to a jury. Hello from India. Dr. My mom. Hello. For some reason, I think you're not in India. All right, but maybe you are. So it's an objective standard. But here's the thing. I've written about this before. So I told you everything pretty much you need to know about qualified immunity, except why do we have it, and why should we get rid of it? There was a Yale Law Review article that came out that examined this, and it actually did a scientific study on the effects of qualified immunity, because it was originally legislated from the bench by the Supreme Court for the purpose of trying to protect police officers. Now, why that's the job of the Supreme Court, I don't know. But this is the same Supreme Court that, shortly thereafter, or maybe the same time, came out with Terry. So Terry is the case that came up with Terry stops, and that just snowballed until what we have today, when police can pull you over, stop you for pretty much any reason they want to. And once they've done that, they can pat you down to see if you have weapons, because freedom is scary. And then they get to find pretty much whatever's in your pockets. And that's all justified under the Terry case, that it was the Warren court. It was just awful for individual freedom, individual rights for the citizens. But they did a lot of proactive legislating from the bench for law enforcement, and a lot of that is still around today. So that's what it was for. It was supposed to be a means of protecting police officers from personal financial liability. And still today, on social media and in Congress even, you'll hear them talking about, well, we need to strip qualified immunity. We need to get, and no, you can't do that because the police officers can't afford it, etc. All that is a red herring argument. And if you look at this Yale Law Review article, it explains why. They did a study of 1,183 lawsuits against state and local law enforcement defendants over a period of 2 years in 5 different federal district courts. And surprisingly, they found that the defense of qualified immunity, and these are all civil cases, all Section 1983 cases, that the defense of qualified immunity was only raised as a defense in only 37% of the cases. And then out of those, qualified immunity only resulted in dismissal in 3.6% of the cases. Now, is that surprising or what? Can qualified immunity really be the reason we have issues right now with police misconduct or division in our country over police misconduct? Qualified immunity only dismissed 3.6% of the 37% of cases where it was even raised as a defense. And why wouldn't it be raised as a defense? I can tell you why. Because again, if I have the groin kick case, and I'm the defense lawyer, probably the insurance adjuster is not going to let me file a motion to dismiss based on qualified immunity, or maybe a motion for summary judgment based on qualified immunity, just to do it when there's no chance it's going to get granted, because they just know from their experience this is going to trial, because was he kicked in the nuts or was he not kicked in the nuts? That's not a legal issue. That's a factual issue. That's got to go to a jury. So if they're going to pay me by the hour to draft a memorandum and file it, and draft a reply memorandum and file it, then great. But they're not going to pay him to do that, probably, because it's going to be a waste of time. So a lot of times it does result in a waste of time. So this study also found that it sort of needlessly brought legal fees up, because there's a lot of litigation. There's a lot of litigation over qualified immunity. That's most of the litigation. So I can litigate a excessive force case, and I hardly have to do any legal drafting, because I can copy and paste a lot of it. There's not a whole lot of novel arguments that you have to bring up. You probably spend more time drafting the jury instructions. But every time I take a search and seizure case, I say to myself, as I'm sitting here at like 10 o'clock at night before a deadline, typing away, didn't I learn my lesson last time? Because that's where you're doing you're trying to find cases that are similar, and you're comparing and contrasting cases. You're doing a lot of reading and writing to try to prove that case, because the gray areas are always going to be the search and seizure cases. So it hardly ever applied during the period of the study. The last thing that the study found that was interesting was that, not only it just didn't protect police officers at all from personal financial liability, because out of all the cases where they lost it, they still didn't have any financial liability. So out of the 1,183 lawsuits, they broke it down to where there were payments. They broke it down to two different categories. So large police departments and smaller ones. So out of the 44 largest law enforcement agencies that were in the study, that was 70 different large agencies overall. No, excuse me. There were 70 agencies overall in the study, and the 44 largest of those law enforcement agencies, the individual officers who lost qualified immunity due to their conduct and who were personally liable due to their conduct, only 0.02% of the dollars awarded to the plaintiffs in those suits were paid by the individual officers. I'm guessing that was probably like one case or two cases out of all those cases to give that small of a percentage. But in the 37 smaller and mid-sized law enforcement agencies, no individual police officer contributed to any of the payments, the settlements to the individual plaintiffs. Now, those are all cases where qualified immunity was not a factor at all. There was no qualified immunity because as the plaintiff's lawyer, if we get past qualified immunity, what that means is we've stripped the police officer of qualified immunity. He has no qualified immunity. Contrary to what people think, that's what we're going for anyways. Going back to the kick in the kick in the nuts case. So he's not getting qualified immunity. If I convince the jurors, and in federal court there's 8 jurors. In our state court in West Virginia, there's 6. But federal court, civil, there's 8 jurors. If I convince all 8 of those jurors that the officer is liable for the civil rights violations, that he kicked them in the nuts, and that although he probably deserved it, it was a civil rights violation. If I convince them of that, and they make an award of money damages, say they award $10,000 for kicking the guy in the nuts, that officer is already individually liable for that $10,000. The award is not against the police department. It's not against the employer at all. It's against that individual officer. So why, out of all those cases, did the officer who was in the same position as the guy who kicked the groin kicker, why did he not have to contribute anything? The reason does not have to do with qualified immunity or federal law at all. It actually has to do with the employment contracts or the employment dynamics between the police officer and his employer. So usually, whether it's a union type of situation or a private contract between the police officer and the employer, or just a policy, employers will indemnify their police officer employees from these lawsuits. That has nothing to do with federal law, has nothing to do at all with qualified immunity. Because by definition, if they lose qualified immunity, they're liable. They're liable as an individual. So I can't sue. Right? If Officer John Doe works for the City of Charleston Police Department, I can't in federal court under Section 1983 sue the City of Charleston and hold them liable for the conduct of Officer John Doe. I have to sue John Doe, an individual. There are some circumstances where I can sue the city, but that's a different claim. That's called a Monell claim, and those are pretty rare and very hard to prove. That's sort of a policy, pattern of practice sort of case. So if the city or their insurance policy is going to pay the $10,000, that's up to them. I can't force them to do it. If they don't do it, then I'm just left trying to get the money from John Doe. And John Doe he could be left holding the bag. He could be thrown under the bus by his employer. But in reality, it almost never happens. I've seen it almost happen one time when I had a case where a police officer was caught on video punching my client and completely knocked him out cold. They had to call for an ambulance. Somebody pulled the surveillance footage, and he was pretty much caught at that point. It showed a punch that it occurred for no reason, and so they fired him and they indicted him, and they sent me a letter and said, sorry, we're not providing him insurance. So he got a lawyer, or I don't even know if he was able to pay him, but a lawyer represented him and sent me a copy of his use of force policy for his department. And I started basically representing the cop at that point. I'm practically representing both people because I'm trying to get him insurance coverage. So I'm making the case to the city and the insurance adjusters that, look, based on what he was taught, then, it said he could punch the guy if he thought he was taking an aggressive stance or was something like that. And so finally they relented and they gave him coverage. So I've only seen it happen one time. So it has nothing to do with qualified immunity. Police officers are and have been always individually liable for any settlements against them. So while I believe that qualified immunity should be completely taken away because it doesn't do anything, it doesn't protect police officers like it was originally meant to do. In reality, all this stuff is already covered with insurance coverage, and it's not a great defense anyways. All it does is increase the amount of the cost of litigation, and really it increases the hostility of the public against law enforcement because they think that this qualified immunity, they can do anything they want. I mean, it's not true, but that's the sentiment out there. Let's see. So that's pretty much my spiel right now on qualified immunity. Let's see. I got a couple minutes, and I'll see if there's any questions here. DJ Plast, how about personal liability insurance like doctors, malpractice paid? I think there are a lot of police officers who get their own insurance policies, and I think that probably varies by state. I'm not in a position to give much information about that because I'm usually on the other side. I can tell you in West Virginia, like I said, I've only seen one case where an insurance company has tried to throw the police officer under the bus. So all insurance policies will have a clause in them that says, if you commit a criminal act, we're not going to cover it. So a police officer could not go rob a bank and then try to claim insurance coverage and get a free lawyer for the defense of the charges for robbing a bank. So the question is well, where does that stop? If using excessive force against a citizen is illegal, or shooting a citizen is illegal where not justified, where does that cut off and the insurance company throws you under the bus? That's a difficult issue, and I definitely would want my own access to my own lawyer if I were a police officer alleged to have committed misconduct. Rather than just have the insurance company's lawyer, I'd like to have both that and my own personal lawyer who's looking out for me, not just the insurance company. So I think that's probably a good idea. I don't know what it would cost. Cities should not have civil rights insurance. Well, I disagree with you there because that's generally where that's how I'm able to get people paid who've been victimized. But in reality, these are huge policies, and government is huge. So it's actually a small part of what they pay because you got to think of all the car accidents that they're involved with. A lot of these states and cities, they have hospitals and doctors and medical malpractice stuff. They have all sorts of issues, and this is really probably a small part of it. Let's see. James Madison posted a video yesterday where the officers whipped this guy's ass. 30 seconds after the traffic stop, they were fists out on Taylor, Michigan. Hope they strip him. Like I said, I don't know if you saw it, qualified immunity rarely applies in excessive force cases. I mean, it can apply as long as the plaintiff is still alive to testify, and as long as his allegations are bad enough to proceed, then rarely would qualified immunity apply. All right. So a lot of questions about the insurance. I think I answered that. Peanut, looks like Casino needs some moderators. Is that a thing? There, can you get moderators for the comments? Let's see. Officer safety is kicking the intent of the fourth out completely. And that's been since, like I said, the Warren court. And Chief Justice Warren, I think he was from California. Was it? I think his father or his brother or something like that was a police officer who was killed. And so he went on this personal crusade on all these officer safety cases that basically have stripped a lot of our freedoms as we sit here today. Melissa Vaughn, I worry about auditors when they say you're going to lose your qualified immunity to officers because it's up to the judge and judges suck. Well, for the most part, federal judges that deal with these cases have been, in my experience, really, really good. And they have lots of law clerks, and if they rule against you, they'll give you a 30 to 40 page opinion regarding why they ruled against you. And then you have the right to appeal it. So sometimes it turns out in your favor, sometimes it doesn't. But the federal courts are by and large, a lot more reliable than the state courts. And again, if a court doesn't tell you why they're ruling against you, there's a problem. And that almost is always the case in federal court, and they're all published generally. So you can search what the other trial courts in federal court have done, including the judge that you're in front of. And in state court, a lot of time, you'd never know, especially in West Virginia, you'd never know what a trial judge had ruled on before in regards to a particular issue, unless somebody had just happened to share an order with you. I hate qualified immunity, absolute immunity, and diplomatic immunity. Well, absolute immunity is a great immunity to have if you're being sued. That's what judges have. That's what prosecutors have. But both can lose their absolute immunity under certain circumstances. And you can see some of my other videos that discuss that. Prosecutors have been sued much more than judges. If prosecutors generally, if they step out of their job as a prosecutor and into the role of a police officer, then they can get sued. Judges are almost never can be sued, but we'll see. All right. Well, I'm out of time, but I appreciate you watching. Again, that is qualified immunity in a nutshell. And you could make a series of 10 of these videos on qualified immunity. It's a very complicated topic. You can email me at my law firm email, or check out the website, thecivilrightslawyer.com. Make sure that you subscribe to the YouTube channel, and also on thecivilrightslawyer.com, that if you want to be updated on any of our cases. So I will see you next time. Appreciate you watching.